Good evening. Every Tuesday, we bring in immigration updates from Houston, Texas. And we do take live questions from 5 p.m. Central Time to 6 p.m. Central Time. Emily, what do we have today to discuss?
Today is October 1st, which means it is the first day of the fiscal year. So today is the day that next year's green cards come out. It's the day that next year's H1Bs start. So we'll be talking about what we can expect, particularly in the visa bulletin over the next 12 months, as we have an entire year's worth of green cards available again. We'll also talk about unemployment when you have an employment-based 485 EAD, the GC EAD, where you are the main applicant based on an I-140 approval. What are the rules regarding that situation? Is there a 60-day grace period? Do you have to always be employed? How does that work? And then a common question we get is when someone is switching from an H-1B to an H-4, can they keep working while they're waiting for the H-4 to be approved? There are many situations where that is possible to do. So just filing the H-4 doesn't necessarily mean you have to stop working immediately. And then lastly, how does it work when you need to file your H-1B transfer, but you have a B-2 pending? Either you filed the B-2 and you're still within your 60-day grace period, or what happens after the 60-day grace period ends? Can you still file an H-1B transfer in that situation?
With regards to the new year, Happy New Year for immigration. So I know that H-1B starts on October 1st. Everything starts on October 1st for USCIS. And of course, for most of our immigrant community and what we deal in, the new year is actually October 1st for us, not January 1st. Emily, we know that the visa numbers are going to come down, and we did predict USCIS in its October visa bulletin, which was released somewhere in September 2nd week, Emily, they did not move the filing dates much for EB1, EB2, and EB3. What do you expect? Is that where we are going to be, where the filing dates are going to be final action dates by the end of this year? Or do you expect any great movements in EB1, EB2, and EB3 for Indian nationals?
I'm not expecting any great movement. So we looked at the numbers from the most recent inventory statistics that USCIS put out. That's the number of 485s that they have pending. And they basically, for EB1 India, they already have enough 485s pending to utilize pretty much all of the green cards for this year. So I do expect only a little bit of movement between February to April 2022 over the next 12 months. It's going to be very slow. And, same thing for EB2 and EB3. They still have, let's see here, 32,000 EB2 485s that the priority date is not current. And because the rest of world has a cutoff date, that means the 7% cap is going to apply to EB2 again this year. So we only get, 2,802 green cards for the entire year for India and EB2, and there's 32,000 pending. So it's going to take forever to get through just what's already pending. I think it's going to take, my guesstimate is about 12 years to get from July 2012 to December 2014, which is where we were back in October 2020, 4 years ago. It's going to take 12 years still to get through that. With EB3, we have still 16,000 pending 485s where the date is not current. And again, only 2,800 can be approved every year. So that's going to take about 6.5 years to get through to December 2014, where we were back in 2020. So if you combine those two, assuming that most everybody that's got an EB2 also has an EB3 because of the downgrade situation that we've had over the last couple of years and the flip-flop between EB2 and EB3, the number of 485s in EB2 and EB3 combined for India that are already pending is 51,000. So if you combine the number we have available, that's about 5,600. So how long is it going to take us to get through 51,000 485s of people that are already pending? That would be about 9 years if we're just doing kind of easy math there. So definitely not looking good for EB2 or EB3. EB1, I don't think we're going to see any positive movement there as well.
Yeah, there are a lot of people who are cutting the lines from EB2 to EB1, EB3 to EB1. So that may also backlog the EB1, or at least there will not be much significant movement in EB1 for Indian nationals. Emily, what about the political scenario right now? We have the election year right now that's going on. Any miracles, anything that can happen? One is the labor accession that is coming in right now. And then a new administration is going to come in starting from January.
Yeah, so I think now is the time that people should be gearing up for advocacy in support of eliminating the 7% per country limit, which is causing a lot of the, well, pretty much all of the frustration stems from that. We've been adding Band-Aids to it over the years with H4 EAD and the I-140 compelling circumstances EAD and even AC-21. 24 years ago, we passed AC-21 to keep allowing people to get those extensions of H-1B beyond the 6-year limit because we knew there was this growing backlog. So it is time for us to pass something, and November and December is the perfect opportunity to do that. As you mentioned, it's going to be the lame duck session where the current Congress is still in session, including people that may not have gotten reelected or may not have sought reelection. They might be willing to make some deals before they ride off into the sunset. So about this time, every 2 years, we start to see a lot of activity on the Fairness for Highly Skilled Workers Act and the EAGLE Act. So now is the time where that might come into play again. We may see some positive movement on legal dreamers. They do a really good job of advocating, and there's a lot of support to do something for them. I don't know exactly what it would be, but they seem to get a lot of movement. We got the change in policy to allow us to use the filing date for purposes of calculating Child Status Protection Act age. And then they even recently came out with another interpretation of that to open it up a little bit further, make it more clear that people in certain situations were allowed to still qualify under that. In terms of election, I think if we reelect or, basically reelect the same administration we have now, if Kamala Harris wins, we'll see more of the same. Where the majority of their focus and attention is on the border, on asylum, on everything but employment-based immigration. And if Trump is elected, I think we'll go back to how things were 2020 through 2020. Gosh, I can't even think. 2016?
2016 to 2020. Oh, do you mean the priority dates are going to move, Emily, because Trump?
No, definitely not that, because that was only COVID that did that. But all the terrible things that happened under Trump, where we ended deference that caused us to get denials of extensions of simple visas where people had been approved years and years over and over again. All of a sudden they get a denial and have to leave the country. We had issues with people getting delays with visas. Part of that was COVID as well, of course. He wanted to eliminate the 3-year extensions for approved I-140s. He didn't move forward with that. He wanted to change the way prevailing wages were done, change how the lottery was conducted for H-1B, just a lot of things that would really upend the current system and may not necessarily in a good way. He's definitely not pro-immigrant, I would say, based on a lot of the rhetoric, even though he claimed he wanted to stamp green cards to people's master's degree. I don't really see him doing that. So it'll be some change coming up for sure.
Emily, what about on the second topic of unemployment? People are under the assumption that if you have a GCEAD, if you are the primary applicant, I'm speaking about the primary applicant only, not the dependents, you can be unemployed. You can be unemployed. Is that right on adjustment of status?
Maybe. I think that the whole I-140 labor certification 485 process is based on having a job offer of employment. So it's not necessarily based on your actual employment, but for most people, it is based on their actual employment. It's their current employer that sponsored them all those years ago. And so they need to keep that job in order to keep the process going. And if they lose that job, although the EAD doesn't require you to work to maintain any kind of status, it's just a document that allows you to work if you want to, you still need to make sure that your 485 is supported by a valid job offer. So to say that you can just hang out and be unemployed because you have an EAD is definitely not accurate. It's important that you always have a valid job offer of employment to support that 485, and that offer has to be similar to the one that you were originally sponsored for if you are no longer with that company.
It's always, if you are unemployed, if you're a main applicant, if you are unemployed, if you're contemplating unemployment, though, you should take the consultation of an immigration lawyer, weigh in the risk to see if it's worth for you or what are the alternative options. Self-employment and other things can be considered for you to avoid any denials of the 485. Now, even though job offer is the requirement, if you have a job offer and if you are not working on it, the officer may think that you're not interested in working. You may deny the 485 application. There are risks associated with it. They are going to look into if the job offer is genuine or not. So you should check with an immigration lawyer on that, though.
Yeah, and I would add, I think a lot of people think that there's a 60-day grace period because they're used to that from H1B and TNs and L1s where that is there. But for an EAD, there's no such thing as a 60-day grace period. So you should always have a valid offer of employment the entire time your 485 is pending up until you receive your green card.
Now, if you are a dependent adjustment of status EAD, though, there are no such restrictions. You can be unemployed. You can be delivering pizzas. You can be an immigration lawyer on a dependent 485 EADs. In fact, I did all three of them when I was on the adjustment of status EAD. I was unemployed, I delivered pizzas, and I became an immigration lawyer while my 485 was pending. That's all allowed if you are an independent. All we are speaking about is if the primary person is contemplating an employment, that is going to be risky. Emily, this is the million-dollar question that comes to us. A lot of times, I am an H1B. I'm working for company A on H1B. My H1B is expiring in October of 2025. If I file a H4 plus EAD right now, do I need to stop working or can I continue working with company A that has the H1B, even though I filed a H4 plus EAD?
Yeah, because your H1B is not expiring and you're still working for the company that sponsored that H1B, you can keep working. You don't have to stop working just because you filed the H4. The H4 application, that I-539 form, allows you to select the start date that you want the H4 to take effect. So if you're selecting a future date to where it'll take effect upon approval or on a specific date, maybe you know that you want to keep working for the next 6 months. So you select May 1st, 2025 is the date you want your H4 to take effect. You can keep working on your H1B, no issues at all. And then if you file the H4 and the H4 EAD together, they are normally approved together to allow you to seamlessly transition from H1B to the H4 EAD without any gaps in most situations.
Can I transfer my H1? A lot of people are transferring right now to B2 application, Emily. USCIS has recommended that people can move on to B2, and USCIS is told in the website that they're going to approve, in the Twitter and website, they're going to approve the H1B when the B2 is pending. Do you see any difficulties in people moving to B2 and from B2 to H1B? Do you see any difficulties, Emily?
None at all. I mean, every once in a while, I might get an RFE on the B2 itself, just confirming the details of non-immigrant intent. but that's pretty rare. And I cannot think of any situation I've had where there was an RFE or definitely not a denial for someone who is switching back to H1B, whether the B2 was pending or already approved. And we've been filing those, pretty much as soon as that guidance came out. We were still dealing with the effects of COVID. People were still being laid off. So we started taking advantage of that right away. So it's been years now and never had any issues with getting the H1B approved or had problems with the B2.
Have you seen any difficulty getting in B2 filed and getting approved if the person has an I-140 approval only after March of 2000? Okay.
Nope. And the I-539 form asks, have you ever been the beneficiary of an immigrant petition? And we check yes, because that's what an I-140 is. And I can't think of any case where we've gotten an RFE on that particular issue. I think it's pretty much assumed if that's the reason, if you're going from H1B to B2 and you have that I-140 and you can't file a 485, I think USCIS expects you don't really have any other choice but to file that B2 or exit the country. And so they don't seem to have an issue with having an approved I-140.
Emily, let's go to Q&A. I have questions from a person, I don't want to name the person. The spouse of that person has a misdemeanor of petty theft. That's most probably shoplifting. 14 years ago, the charge has been dismissed and the whole case is expunged. Will that impact anything on the I-485 application or any problem we can expect in the interview? One, it's just a hurdle that you will have to face. You will have to disclose that information, even though the case has been expunged. You will have to disclose that information in the I-485 application. You will. There is a chance that you will be interviewed. You need the final disposition and the expunged record, especially the expunged record. You need to have a certified document of those things for you to file the 485 at the time of filing the 485 and also at the time of attending the 485 interview. But under the circumstances, have we seen any cases getting denied because of this particular issue? I have to admit, though, no, I have not seen any denials.
Barkov says, can we sue USCIS or Congress to fix the EB2 or EB3 backlog? I think a lot of people have tried to come up with the legal background that would support such a filing. And I don't think anyone agrees that it would be successful. Ultimately, the Constitution says Congress gets to make the laws. They make the laws about immigration. They're in charge of it, and that's the law that they set. It doesn't violate the Constitution in any way. And so there's no way to sue them for making that particular law. The best thing we can do is advocate for them to change the law or advocate with the administration to change how the law is interpreted, particularly when it comes to counting spouses and family members, because really when we're talking about 140,000 green cards, those should be meant for the workers, and the family members should not be counted towards that limit. That would greatly expand the number of green cards available and do a lot to relieve the backlog that we're in. And that's something that is consistent with how the law is written. It just requires a change in interpretation from the administration. So, but I don't think lawsuits are going to work for this particular issue.
Now, 45 from YouTube has this question. Can I go to Mexico and get H1B stamped after traveling on AP to India? Yeah, you can go and get the H1B stamped after traveling to India and AP, but I don't see why you need it though. That's the only purpose that I would see. You'll be unnecessarily, if you don't get stamping there are some negative consequences for it. But yeah, technically, can you go? Absolutely you can, no problem with it.
Riz says, can we renew an L1A visa if it's already expired? It's been expired for over 3 months. I'm on the GC work permit and awaiting the AP. Yes, but it cannot be done while you stay in the US. So basically, your company would need to file a new L1 petition in consular processing. It cannot be a renewal because you're already out of L1 status. Once it's approved, you need to exit, apply for the L1 visa stamp, and come back, and then you'll be back in L1 status. But if you don't have an AP, when you exit and get that stamp and come back, your 485 might be abandoned. You may need to refile it after you return. But yes, you can get back into L1, assuming you've not used up your 7-year limit.
Samrita Basu has this question from Facebook. She got laid off recently. She has an I-140 approval. Which one is better, compelling circumstances EAD or B2? One B2, especially if you don't have a stamping available in the passport, B2 may be better because it's easy for you to move back to H1B from B2. Compelling circumstances is better if you already have the passport stamping. Let's say you're working for company A and you have H1B valid until 2026 and you have the passport stamping until 2026. You can then at that point of time apply for compelling circumstances, because even though you can't move from compelling circumstances back to H1B, you can do a consular processing, and without going for stamping, you just have to step outside the country and come back in. So there are sometimes the compelling circumstances may be better. There are sometimes B2 may be better. Most of the time we recommend B2 visas to the people. What are the risks associated with it? What are the success rates in it? B2 almost, I don't know, everything gets approved. Compelling circumstances, I would say that at this point of time, the approval rating is above 90%. Now, by any chance, compelling circumstances gets denied though, will it have any negative consequences in the long term? No, you just have to leave the country and you have to come back once you get the job and H1B.
Sarah Vanan says, my priority date is June 2015 in EB3 for India. When will this date be current? Well, we've said time and again that we're terrible at predicting the visa bulletin priority date movement. We've gotten slightly better at it because we have more statistics available. We've been going without the I-485 pending inventory for a number of years, since basically the Trump administration. Now we've been getting it every 2 weeks or so. They've been updating it. So we do have that data. Based on that data, I would expect, if we're looking at only the number of EB3 485s that are already pending, it's going to take 6.5 years to get to December 2014. Then you've got to make it another 6 months to June 2015. So it might be between 6 and 10 years. On top of that, you have to think about people who are in EB2. If EB3 starts moving ahead, those people are going to downgrade or switch back to their EB3. So that might make it closer to take 9 years to get to December 2014. Then we've got to get another 6 months beyond that. So it could be, as I said, anywhere between 7 and 10 years, maybe even longer than that, for a June 2015 date to become current without any change in the law or how we interpret the law.
Questions are coming with regards to the domestic stamping. Of course, as we already know that they did a kind of trial run on domestic stamping. It was pretty successful though. People had the domestic stamping very successfully. But we don't know when they're going to start going for all the people who probably like H1B extensions, all those people, H4 extensions, when they're going to do it, we don't know. The way the government works is very slow. It's not like private law firm, okay, you got something, why don't you start doing it? Yeah, we'll expand it, we'll hire more people, and we'll continue doing it. That's not how the government works. They take time. They have a lot of different considerations, but at this point of time, they haven't made any press statements when they will expand the domestic stampings of the H1B. We really appreciate them doing it. This would avoid and take a lot of burden on going outside the country and getting stamping. Nowadays, especially to go to India and get the stamping, is becoming a nightmare because of the delays in the appointments.
Senta says, do you expect EB1 priority date for India to be current before October? No, EB1 is not going to be current for India at all. It's going to stay where it is or get worse, but I don't see it getting any better. We already know that this was as of June 2024, there were 16,800 people with approved I-140s where the priority date was not current. USCIS, the one thing that EB1 benefit compared to EB2 and EB3 is they get the spill across that the rest of the world doesn't use. So while EB2 and EB3 are limited to about 2,800 visas each year in each category, EB1 India usually gets on average about 10,000. So if there's 16,000 already there in the pipeline, it's going to take, what, a year and a half to make it through those, and you're just keep adding every month more and more people are filing. So no, I would not expect EB1 India to become current.
Question from Arya Place. If H4 extension is pending, if the H1B person travels, will it affect negatively on the H4 application? Absolutely not. They can travel, H1 person can travel. It will not negatively impact the H4 extension if they are just visiting outside the country and coming back into the country. MKC from YouTube has this question. Is there a timeline to get a job on F1 OPT? I'm assuming that you are on the initial OPT, that's 1 year after you graduate. You are allowed to have only an unemployment period of only 90 days, not more than that. Now here, MKC, that what I want you to notice is that an unpaid internship in the OPT period will count towards employment, will not count towards the unemployment. So unpaid internship is allowed in the OPT. It is not allowed in the STEM extension, but it is allowed in the OPT.
Sudarshan says, I'm on L1B status for 3 years and got an extension for 2 more years. What are my options for staying and working in the U.S. for a longer period than 5 years? Is an I-140 approval going to help? So an I-140 approval won't help you extend beyond the 5-year limit of L1B. One thing that you could do if your U.S. position has progressed to be a managerial level position or even an executive level position, you can convert your L1B to L1A, which will get you an extra 2 years of L time. That's one option. Another option is to recapture the time that you spend outside the U.S. during your 5 years of L1B time. So if you've spent cumulatively over the last 5 years, 1 year outside the U.S., you can extend your L1B for an extra year to get basically 6 years of L1B time. What the majority of L1Bs do that I work with, we get them an approved I-140, either through the PERM process, usually EB2 or EB3, get that I-140 approved. Maybe you could do an NIW, but it's still going to be EB2. But what you also have to do is convert to H1B, because then the H1B will allow you to keep extending beyond the 6-year limit. But you have to make sure that you don't use up 6 years of L time before you get over to H1B, because the time you spent in L counts towards the H1B 6-year limit. So you have to be careful on the timing of that, and you've got to make it through the lottery. But that is typically how we handle that situation for people that need to stay longer who have an L1B.
Question from Ting Song from Facebook. I was born in China. My priority date is May 2022. Can I downgrade from EB2 to EB3 when EB3 is current? Absolutely, you can. When you do downgrade, Ting, you can file, assuming that the priority date is current at that point of time, for May 2021 for Chinese nationals. You can file the 485 at the same time when you file the downgrade. So it's I-140 to file the downgrade application from EB2 to EB3. You don't have to file the PERM application. You can use the old PERM application to file the I-140 EB3 and file the 485 and of course EAD and AP along with your 485 application.
Mohan says, if the current H-1B petition has expired and the extension is pending already with USCIS with company A, can a new company B file an H-1B extension at this time? Or really that would be a transfer. Can they? Yes. Should they? Or is there a safer way to do it? There are ways to get it done. Because your current H-1B has already expired and your new one is not approved yet, if you now file a transfer and you leave your old company, they might withdraw your pending extension. That withdrawal is going to create a gap from the end of your I-94 of your previous H-1B to the filing date of your transfer, which means your transfer is likely to be approved without an I-94. That means consular processing. You're going to have to exit, possibly get the visa stamp, probably get the visa stamp because that would be expired as well, and then come back to regain your H-1B status. So the better thing to do is to upgrade the pending extension to premium processing, get that approved, and then file the transfer, or just plan to file the transfer consular processing and then exit when it's approved, get the stamp, and come back in.
Executable is asking the question, is it advisable to travel an advance parole after submitting RFE response? This is speaking for the 485 application, the RFE response. And the RFE response is not related to medical. I would like to look into the RFE response to see if there is any risk involved in it. If it's clear case, okay, they asked for the birth certificate and then now you provide the birth certificate and you provide the non-availability of birth certificate and then you provide the rest of the documents. Those kind of simple things, I don't mind you traveling. But if it's something employment related, there are some issues there, definitely not.
Muthu says, my spouse came on H4 and her stamping is valid till February 2025. She then moved to H1B. Now, can she go out and come back with the existing stamped H4 visa, or does she need to go for new H4 stamping? Well, assuming she wants to be back in H4 status, her H4 visa stamp is still valid until it expires in February, even though there's that intervening H1B change of status. So she can go out and come back on H4, no need to get a new stamp. If she's wanting to travel but get back to H1B, then she either needs to get the H1B stamp or she can only travel to Canada or Mexico, use automatic revalidation to use the H4 stamp plus the H1B I-797 that has an I-94 on it. Then she will be allowed back in H1B status without getting the H1B stamp. But that's only for Canada or Mexico for trips for less than 30 days where you have not applied for the visa stamp. Clevy says, where can I get a first-time H4 stamping as a third country national? Is Canada a good option? There's no technical restrictions on that anymore, really, since COVID. All of the consulates are options as long as you can legally get to that country. Canada, I believe you have to get I'm not a Canadian immigration lawyer, but you would likely need to get a visitor visa to go there. On top of that, I think they are restricting their visa appointments to Canadian citizens and permanent residents. So you may not even be able to get an appointment there. But assuming you can, we've definitely had people apply in Canada and in Mexico as well.
Ahmed has this question, can I get an advance parole the same day from the USCIS if there is an emergency? Have I seen some people getting it? Yes. But for most of the people, I would say 95% of the people, they won't give it on the same day. So if you have contemplating anything where you're expecting some emergency to come, what I would recommend is to the USCIS, which also takes about 70 days, and you should do it very well in advance. But don't expect if you have real emergency, they're going to give an advance parole on the same day.
Kieran says, I have two I-140s, EB2 and EB3 approved. Can we switch between them, whichever one is current? Yes, that's what we refer to as transfer of underlying basis. So if you file your 485 in EB3 because EB3 was current and later EB2 becomes current, you can request a transfer of underlying basis of your 485 from the EB3 to the EB2. Now we do that through the supplement J form. And you can go back and forth as many times as you want, as many times as EB2 and EB3 flip-flop.
Question on the DS 160. Do I need to provide that registered LLC company details? This question is coming from KR. The person is going for H4 stamping. It depends on where they employed or they just own the company. If they just own the company, you don't need to disclose. If they have been employed, they did some work for the company, then you need to disclose that information on DS 160.
Hari says, do we need to inform the employer after getting the GCEAD, and do we need to update the I-9 form? Currently on H-1B, planning to relocate to a different city without informing the employer. So getting the GCEAD, there's no mandatory requirement for you to inform your employer, and they are not required to update your I-9 because they only have to update your I-9 when your current employment authorization is expiring, which is the H-1B. That being said, you should definitely tell them if you're planning to relocate and you're on H-1B, because to continue in H-1B, they're going to have to file an amendment. If you're intending to switch over to EAD, they need to know that you have that option and are planning to do that. So definitely do not move location if you are on an H-1B without your employer being involved in that decision.
Okay, 1 second.
VSRV says, is it normal to still have my H-1B pending with USCIS in regular processing, even though it's already October 1st? Yes, it is normal. They just because the visas start on October 1st, USCIS is not required to adjudicate them by October 1st. They do generally try to prioritize, especially the master's cases where people have OPT and cap-gap time running out. But yeah, they can definitely go well beyond October 1st. There's no requirement for them to approve them by October 1st.
Sanjeev Kumar is asking the question. He got USCIS to do the motion to reopen the denial of the I-485, but his spouse 485 has not been reopened. My simple question to you is that when you filed a motion to reopen, did you file for you and your spouse separately? If you did, then they should reopen. If you did not, then you may want to contact an immigration lawyer to see what is the next course of action. Question from Kedar. If I apply from compelling circumstances EAD, I have a B1, B2 stamp in the passport. Can I travel on B1, B2 after applying for the compelling circumstances EAD? I would strongly recommend don't. Because when you travel on a B1, B2, your intention should be only to come temporarily in the United States. And if you already applied for compelling circumstances EAD, I would recommend that you travel.
Budding Learner says, can I do the margarita switch? My H-1B visa stamp is valid till September 2025, but my I-94 expires in March 2025 due to my passport expiration. And I switched to a different job, and my H-1B I-94 is valid to January 2027. You technically don't need the margarita switch because you have a valid visa stamp. So any time between now and March 2025, before your I-94 expires, you can travel to Mexico, come back, show your valid H-1B visa stamp that's good till September 2025, and be sure to show them your I-97 approval with your new employer that has the I-94 on it that's valid till January 2027, and make sure they give you that January 2027 end date on your new I-94, which you will print from the CBP website.
Sagar is asking this question. What documents do I need when I go for H-1B stamping? I have an I-140 approval. Nothing, just regular H-1B documents, pay stubs, W-2s, copy of the entire H-1B petition, LCA, that's normally required. You can just add an I-140 approval to it. That's all you need, nothing else. Just the regular documents for H-1B plus I-140 approval.
Raza says, is it easier to have a consular L1B blanket extension or stay in the US and apply for the individual L1B extension by filing with USCIS? I would go consular processing every time. We definitely were doing that pre-COVID because USCIS for L1Bs, even L1As, they're just so skeptical of everything. Every case is getting an RFE asking, does this person really have specialized knowledge? Does their old job in their home country 10 years ago really use specialized knowledge? Does your new job in the US actually use specialized knowledge? So especially if you came in under the blanket, when you file an individual petition with USCIS, even though it's under the blanket, you're still filing an I-129 along with the I-129S. They treat that as a new filing, meaning there's no deference to the approval that you got at the consulate. So very likely to get an RFE, no guarantee that you'll get the approval. Of course, there are never any guarantees with consular processing either, but generally applying for an L1B at the consulate under a blanket is a billion times easier than filing with USCIS. The only time we filed with USCIS was during COVID because the consulates were closed.
Jagdish has this question. He has an EB2 priority date to 2016. Can he use that priority date when he applies with the EB1 from a completely different company? Can he put the date from EB2 to EB1? The answer is fairly simply yes, you can. The EB2 from company A can be ported to EB1 from company B. Absolutely not a problem. Srihari has this interesting question this question comes very often. I'm an H1B and I have an AP. I've used my AP to enter the United States. Can I switch my job on H1B now? Is the H1B still valid? I'm assuming, let's say you have a company A's H1B, which is valid until October 2025. Now you traveled on advanced parole and came into the United States. Can you move from company A to company B? Absolutely, you can. If the validity of company A's H1B is still there, even though you traveled outside the country on advanced parole, even though your I-94 says that you traveled on advanced parole, you can convert your H1B with company A to company B. Absolutely not a problem.
DP says, my GCEAD was approved in March 2024, but I still haven't received it 6 months later. I've opened multiple inquiries to no avail. What can I do? Refile the dang thing. These service requests don't work. Just file it, get it over with. Once it's filed and you have the receipt number, try to do an expedite, call USCIS, the 1-800-USELESS number, tell them that you had to refile this due to USCIS error because your previous card got lost. You need the card to be able to work, make whatever arguments you can to try to get it expedited, but that's going to be a million times faster than waiting for them to fix their mistake.
A question from Masala Zilla. What happened to the H4E? What happens to the H4 EAD if I get divorced? Can I continue working on the H4 EAD? Once you get divorced, your H4 is no longer valid. Your H4 EAD, thus why, is no longer valid. Before you're contemplating and getting the divorce finalized, you need to move to other visas for you to stay legally in the United States.
V says, my friend has been without a job and without pay stubs for close to a year on H1B. If he gets a job now, will there be any issue now or later? If yes, what sort of issue? Definitely not a good idea to do that. If he has the job offer now, that petition should be filed requesting consular processing. And then once it's approved, he can exit. If the visa stamp is already there, he can come right back in on the same visa stamp if it's not expired, even though it has the old company name on it, and get back into status and get back to work. Whatever you do, do not submit fake pay statements to try to get a transfer approved with the I-94. That's the worst thing you can do. That's fraud. That's misrepresentation. That will bar you for life. Do not do that. The easy solution, just file the petition, get it approved in consular processing, exit, and come back in. Being out of status in the US because you were not paid because of a bad actor employer, that is not a grounds for you to be denied in the future. It's not something that makes you inadmissible. You're just out of status. How do you fix being out of status? You travel and come back in. Easy way to fix it. It's not going to harm you in the future because you've traveled and come back in. But if you continue and try to file and try to make arguments, try to submit fake documents, try to get, don't have that employer run a payroll and you pay them back. Don't do any crazy, shady things. That makes it worse. Just fix it by traveling and coming back in.
This question is coming from Suparna Roy from Facebook. What is the response time for the compelling circumstances EAD? We're noticing some of the cases we're getting approved within 2 months. Some of the cases they're taking up to 6 months for compelling circumstances EAD. Question from Surya Teja. Can a person on H4 valid until September 2025 convert into J1 medical residency with premium processing in USCIS? Absolutely, they can. They can, because premium processing is now allowed for J1 visas. You can do premium processing in J1, no problem with it at all.
Gagan says, is there a possibility of fast processing for an I-131 travel document? Advanced parole processing times are terrible. They've been terrible for some time. USCIS is not getting any better on that. So the best thing we do is file a lawsuit in federal court, and we're able to get those I-131 cases approved. You could also try to do an expedite request with USCIS, but it's discretionary. So if they don't think your situation is serious enough, they can deny the expedite and you're stuck with the regular processing time.
Sandeep Vallabhanini has this question. My 485J with old employer got approved along with a 485. Will this cause any problem at a later date for me because I'm no longer working for the company? I got 485J and 485 approved on the same day. Absolutely, that's not going to cause any problem whatsoever at all, Sandeep, in the future for you.
Krishna says, does a TN or E2 visa make an EB2 petition void? No, they're completely separate processes. A TN and E2 is a non-immigrant temporary short-term work permit. An EB2 petition is for you to eventually get the green card. One does not impact the other in terms of making one void or not, because they're completely separate processes. Now, if you're getting that TN or E2 with an employer that's different from the one who filed your EB2 petition, although that EB2 petition is still there and it's still valid, you may not be able to use it to file the 485 because you're no longer with that company. But it doesn't automatically go away just because you got a TN or an E2.
Jitin Jacob from YouTube has this question. When you file the H1B, H4, and EAD together, are you seeing the approvals at the same time based on the agreement between USCIS and the Idukki's case, which Stephen Brown from our office was the lawyer for it? Yes, we are seeing H1B, H4, and EAD approved at the same time. Now, once in a while, we do see the H4 and EAD not getting approved at the same time. But if we contact the USCIS, we are getting them approval very fast. Within a week's time, we request the USCIS and they approve it very fast. Now, we have a different way of contacting the USCIS, and that's the reason we get it. So if you have anything where your H4 and EAD has not been approved along with the H1B, please contact us. We will get your H4 and EAD approval. Not a problem at all.
Avi says, how should I interpret the PERM processing timeline? It mentions a 430-day processing time, but I see very few pending cases from more than 5 months ago. I think you're looking at two different things. So the PERM processing times really are 430 days. They've been taking well over a year for a very long time, and that's entirely normal. The few pending cases from more than 5 months ago, you might be looking at the prevailing wages. Those case numbers you can look up. Those are different from the new case numbers that are in the flag system for perm. So yeah, it is 430 days for sure to get a perm approved right now.
Sangeeta Acharya has this question from Facebook. Her husband got laid off and she wants to see when does the 60-day grace period start. They have given the termination date. The laid off date was August 20th. I'm just making the story here. And the termination date on the letter is September 20th. And the husband is getting paid until November 20th. What is the date here? We normally look into the paycheck. When is the paycheck? If the paycheck is coming for the severance pay, does it say it's a severance pay? Does it say a normal pay? In cases where it just is looking as if that it's a normal pay, we have made an argument that it's November 20th is when the 60 days starts. We've been successful. But we normally request to see that in this case, it's now you have given 3 days. Laid off is August 20th, and the termination date is September 20th. So that's really confusing why they give 2 particular dates, though. But if they have paid until September 20th, the normal pay, then you are perfectly all right. You can start counting from September 20th. Now, the November 20th, where the severance pay is only in emergency, we go and try to use the November 20th. In your case, since you have been laid off on August 20th and termination date is on September 20th, you got paid until September 20th under the normal pay. It's better to be safer, but considering September 20th as a start, as the 60 days, not November 20th, because that's a severance pay. Because in the severance pay, the USCIS has a discretion to say that, hey, it's a severance pay. You did not work for that company, or you've been terminated earlier. So as a better strategy, I would take September 20th.
Gina says, why are some people not able to see the documents option in their My USCIS account for AOS cases, while some can access their documents electronically? Is it something to do with self-petitioning versus filing with a lawyer? No, I don't think so. I think it's just this janky system that USCIS came up with. I put my USCIS account number on every single thing I file with USCIS. I have some that show up 3 or 4 times in the system. I have some that don't show up at all. I have some that show documents. I have some that don't. It is no rhyme or reason to it. I think it's just poor design by USCIS. But you'll be happy to know they got an award for their My USCIS accounts not too long ago for how great it is.
Who gave the award in me?
I don't know. I forget. Stephen posted it on Twitter. It's some Citizens for Public Service or something like that.
Okay. That need to be sent to Smithsonian Museum. Well, did they got award for the best or worst? Did you check it properly?
It said best, unfortunately. I don't know what they were looking at. Mary says, my H1B starts today. My priority date is April 2023, rest of world. My spouse and kids are still on F1 and F2. Do you think I should file for H4 for them or wait for my date to become current? Well, you mentioned your spouse is on F1, so they're not tied to you. So as long as your spouse is going to maintain F1 status, that means your child will maintain F2 status. They don't have to be on H4 to file the 485 with you when their date becomes current. As long as they're maintaining status, that's fine. So I don't see any reason why you have to get them on H4 if that's what you're thinking. They can file for the 485 while they're on F1 and F2.
Jitin Jacob has this question. My wife is born in UAE. She's on H4 visa. Can she apply for diversity visa allotted for her? Absolutely, she can. No problem with it. And if she gets it, and you can be included in it, even though you're born in India. even though your wife is actually has a passport of India and she was born in UAE, then she will still be eligible for applying for the diversity visa. At the same time, Jitin, what you can consider is that if you have an I-140 approval, since your wife is born in UAE, you will fall into other countries where the priority date is way faster compared to Indian nationals. Even though she is not the main applicant for the I-140, you can use your wife's country of birth to file a 485 application.
Shak says, if you submit documents based on your priority date for the filing date, will you receive the EAD? And if yes, does it require you to maintain the H-1B visa? So you don't have to wait till your final action date becomes current to get the EAD. Your EAD is based simply on the fact that you filed your 485 and have it pending. So you can still get an EAD even if your filing date is current, but your final action date is not current. Whether you choose to continue to maintain your H-1B after you get the green card EAD, there's a lot of pros and cons to both. There's many reasons why you don't necessarily need to have the H-1B valid. There's some reasons why you might want to. We've done a couple of videos just on that topic, I think. But you can still get the EAD even though your final action date is not current.
Akhil from YouTube asked this question. My H-1B petition was submitted in the last week of June, and it's a new quota petition. Right now, it's October 1st. What are the things that you need to be careful about? If you're an F1 or STEM extension, you're perfectly all right. If the validity period of STEM extension and STEM extension or OPT is beyond, let's say it's expiring in December of 2024, you're perfectly all right. But if you were on gap, that means that your OPT or STEM extension expired between June and right now, and then you are working on the gap, you have to stop working, because once October 1 starts, you have to stop working. And it may be, if that's the case, though, you may want to convert your case into premium processing to get it approved, because since you have to stop working, you may want to get it premium processing.
Sagar says, what if the employer who filed for the green card is out of business? Can the same priority date be used by a different company when it becomes current, and does the job title have to be the same? So there's two different ways to look at this depending on whether you filed your 485 or not. So if you have not filed your 485, if your I-140 was approved for at least 180 days before the company went out of business, you can still use that priority date, but your new company has to file new labor certification, new I-140, retain that priority date, and then you can file the 485. The new company cannot just use the old company's I-140 to file a 485 for you. If your 485 has already been filed and has been pending for 180 days, then you qualify for AC-21. Then the new company can keep your priority date and keep your 485 going as long as the job is similar to what you were originally sponsored for. The job title does not have to be exactly the same, just the duties have to be similar.
Anything else, Emily?
I guess we are out of time. Thanks everyone for joining us. As always, we will be back next week, Tuesday at 5 o'clock Central Time, to give you the latest updates and answer your questions live. And you can always book a consultation with us or any of our attorneys by going to rnlawgroup.com if you want to have some specific advice about your particular situation.
Thank you very much for tuning.